Hello and welcome to the Vercammen Law Office Legal Podcast, looking at recent cases in New Jersey. And this week we're looking at a criminal case where the State versus Lowy, Lowy. Defendant gives a statement in the ambulance, and the appeals court found it was admissible. So here the defendant appealed his conviction for reckless manslaughter. So elderly defendant went to the park to feed pigeons, even though he knew it was forbidden. The elderly victim thought feeding birds was unsanitary. A dog walker saw two elderly men fighting in the park and then heard the victim scream, "He's got a knife," and called 911. The jogger saw the two men wrestling. Victim asked for help, saying, "This guy's got a knife." He saw the victim holding defendant down on the ground. The jogger told the defendant put the knife down, and the victim released the defendant, who left the park. The defendant was later arrested, but then complains of pain and was taken to the hospital. The defendant argued the omission of his statement he made while in the ambulance and at the hospital violated his Fifth Amendment rights. The court noted the defendant had received Miranda warnings, invoked his right to counsel, and was later taken to the hospital. The court held the defendant voluntarily spoke to officers in the ambulance and at the hospital. The court found his statements were unprompted and unprovoked by the officers, and also were admissible by a party opponent. The medical examiner's testimony that defendant and victim were facing each other at the time of the stabbing was also found to be proper. And this is State versus Lowy. For more information on criminal cases, visit website njlaws.com. And for representation in criminal cases and litigation, contact Ken Vercammen's office in Edison, that fixes, at 732-572-0500. Thank you.